This is a lecture about intoxication, and in particular, when can you use it to defeat a crime that's been charged. Now, one of the first things you want to do with intoxication is to distinguish between voluntary and involuntary intoxication. It's just, there are a lot of other situations in the legal system where you have to do that. In nuisance, one of the early things you do in the problem is to distinguish between a public nuisance and private nuisance. In a manslaughter problem, one of the early things you want to do is to distinguish between voluntary or involuntary manslaughter. And so here you need to point out whether the defendant is going to be claiming involuntary intoxication or voluntary intoxication, because the rules are going to be very different. So let's take a look at these rules. First of all, we all understand that a crime requires an actus reus and a mens rea. And we know that if the actus reus of a crime did not occur, that it really doesn't matter why it didn't occur. If there's no actus reus, the crime simply wasn't committed, no matter what the reason for it may be. And the same concept is carried over to the mens rea. That is to say, if the defendant did not have the mens rea required for the crime, then the crime simply wasn't committed. And by the same reasoning, it shouldn't matter why the person doesn't have the mens rea. If they don't have it, they don't have it. And so that's the general setting in which we are working. And we look at the next level of detail regarding the mens rea, and we see there are several circumstances that might prevent the person from having the mens rea. Infancy, insanity, intoxication, and diminished capacity are the ones that we study. So we're going to see when can we use intoxication to negate the mens rea of a crime. So I guess our next question is, well, what kind of mens reas do you have to have for crimes? And so if you look at the literature, if you look at the books, you look at the case law, you look at the statutes, and you'll see states of mind like these. The person, if they acted wantonly, or willfully, or recklessly, or feloniously, or unlawfully, corruptly, fraudulently, all these different states of mind. And so each crime has kind of got its own state of mind. However, these can be reduced to the three which I have shown here. Those states of mind are always some combination of these: intent, premeditation, or malice. For example, we say wantonly. Well, wantonly, malice is either intent or reckless, so wantonly is the same as recklessly. Willfully, the person acted intentionally. So all of these will equal some combination of these. So these are the fundamental states of mind we have to be concerned about in crimes. Intent, common law. We have two intents here. One is the person might intend to do the actus reus of the crime, and those are the general intent crimes, where the intent was just to do the act which constituted the actus reus of the crime. The specific intent crimes are those where the person not only intended to do the actus reus, but they also intend to do something more. They intended to break and enter into a dwelling house at nighttime with the intent to commit a felony therein. They assault with the intent to kill. They and so forth. In the case of attempt, the person did something which was close to perfecting the crime, but didn't perfect the crime with the intent to perfect the crime. So those cases where you have this additional intent that the person intended to do, those are the specific intent crimes. Now, I call your attention to People versus Hood. That's a California case. And that case, and lots of other cases now around the country, are saying we should stop using mens rea, whether it's a specific intent. They're saying, pardon me, what cases like Hood are saying is that we should use the actual intent to decide whether or not it has been negated. Negate the actual intent and not have these rules about negating specific intent versus general intent crimes. We'll talk more about that later on. A second state recognized in common law besides intent, premeditation. Now, premeditation calls for a special state of mind because the person has to think about the murder and so evaluate and decide, do I really want to do this? And having done all that, that's a special state of mind. And so we treat that as a specific intent crime. If first-degree murder is common law murder with premeditation, well, if the person was intoxicated enough, the absence of you'd argue they couldn't premeditate, so they're left with second-degree murder or common law murder, whichever you want to call it. But you cannot reduce what would be second-degree murder down to manslaughter by negating that mens rea, by saying that the person could not premeditate and they didn't understand what they were doing and so forth. You can't get to manslaughter. It's really a public policy. Now, I'll come back and cover this more thoroughly in just a moment, but let me go through it superficially just to lay out the groundwork here. Malice is the other common law state of mind, and that usually means intent to do the act or recklessly. So these are the three states of mind that we may want to be able to negate with intoxication. These states of mind. Model Penal Code has a different set of states of mind that so that to be criminally liable under the Model Penal Code, I need to mention this because a lot of statutes now are being written in this Model Penal Code language, and the bar examiners could use that, particularly on the multiple choice part. But the Model Penal Code, the mens reas which are recognized in the Model Penal Code are purposely, knowingly, recklessly, and negligently. Purposely means purposely and knowingly kind of make up the old intent, because when you say someone intended to do something, there's really two components to that. This is the way the Model Penal Code people look at it. There's really two components to that intent. If you intended to, got out a gun and shot it and hit somebody, intended to kill them, that really there are two parts to it. One is that you acted purposely with a gun, and the other is that you knew that this gun would kill. For example, if you had the purpose of killing somebody, why not pick up a water pistol and shoot them with a water pistol a few times? Okay? Well, you had the purpose, you still intended to kill them, okay? But you needed to know, if you're going to use you needed to know that guns kill. And it's that way in so much of the intent areas that the Model Penal Code people have separated purposely from knowingly. And so that if you either acted purposely or acted knowingly, that one can have criminal liability for that. Another situation where you have the purposely or knowingly example is a person wants to kill somebody and they do it by planting a bomb on the airplane. Now they just want to kill this person X on the airplane, but they plant the bomb and they certainly know that Y, Z, and W, the other people on the airplane, are going to be killed also. But they can say, I didn't act with the purpose of killing them. I didn't want to kill them. I just wanted to kill X. But they knew the other people would be killed, and so you could, if they acted knowingly or purposely, that's enough for criminal liability. Recklessly, we know about, ignoring the risk of high risk of great bodily harm or death, and negligently. Now, most of the time, you can't get a crime out of negligence, but there's some situations where you can. But recklessly, you can get crimes out of that, we'll come back and talk more about these comments here, that you can negate purposely and knowingly. You can negate either of those by voluntary intoxication. You can, but you cannot negate recklessly or negligently by voluntary intoxication. Now, what we understand at this point is that you need the mens rea to commit the crime, and we understand that at common law, the three mens reas that we might end up defeating would be intent, malice, and what was it? Sorry. The intent, malice, and premeditation. Whereas under the Model Penal Code, there are 4 states of mind, and we need to know whether or not intoxication will negate any of those. So let's look at the rules for intoxication. We begin with involuntary intoxication. Involuntary intoxication, first we need to define it. What do we mean by that? We mean that the person didn't know that this was an intoxicating substance, or they took it by duress, or it was the pathologic involuntary intoxication. I'll tell you about that. Person didn't know this can come from the use of prescription medicines, or they went to a party and somebody spiked the punch or something, so they simply didn't know that they were getting intoxicated. Duress, of course, is going to look for a lot of threats before they will accept the fact that someone got intoxicated by duress. The mere fact that your friends will laugh at you if you don't take the drink won't do. Pathologic, this is the case where the person took a little bit of some drug, a little bit, 2 sips of wine, and little did that person know that their body was so allergic to this stuff that they just freaked out and lost control. But you have to have a situation where the person really had no reason to know that this little bit of use of that intoxicant was going to do all that, and in those cases, that is treated as involuntary intoxication also. So if we have involuntary intoxication, this can negate the mens rea of any crime. Can negate the mens rea of specific intent crimes, general intent crimes. Any mens rea can be negated by involuntary intoxication. Even negligence or recklessness. A person, if they were reckless because they were involuntarily drunk, well, they're involuntarily intoxicated. They're not responsible for that. So you can negate any mens rea with involuntary intoxication. Also, if the involuntary intoxication is severe enough that the person meets the standards of insanity for that jurisdiction, didn't know what they were doing, if they did, they didn't know it was wrong, or whatever the standards are in that jurisdiction, if the person is so involuntarily intoxicated that they meet the insanity standards, then that is also, in effect, that's another complete defense. Now, their defense is not insanity, the temporary insanity because of intoxication. Because if you defend with insanity, the person gets locked up right away, right after the trial. They're off to a civil institution or some such place. But this person is claiming intoxication as a defense, and when it's that severe, it does operate as an affirmative defense. Normally, intoxication is not an affirmative defense. Okay? But when it's this severe and it's involuntary, then you can use temporary intoxication. So that's how involuntary intoxication works. Need a definition? Involuntary intoxication negate any mens rea, and if it's so severe as to create temporary insanity, that's a good defense also. Now comes the big one, which is voluntary intoxication. This is where the problem almost always is in the bar exam. First of all, voluntary intoxication is not an affirmative defense. Affirmative defenses are things where, like, even if you prove all the elements of the crime, if I can prove this affirmative defense, I'm home free. I shoot somebody and they die, and so you can prove I shot them with the intent to kill them, and I hated them at the time, but if my affirmative defense is self-defense, because they had a gun, they were about to shoot me. And so no matter what you prove, the affirmative defense can be established that you get acquitted. And I'm saying to you that voluntary intoxication, I don't care how intoxicated you are, it is not an affirmative defense, voluntary. But even though voluntary intoxication is not an affirmative defense, you can use it to negate the mens rea of the crime. The majority rule is that, and this is very important to mention this on the bar, the majority rule is that voluntary intoxication can negate the mens rea of specific intent crimes. Okay? That's the majority rule of specific intent crimes. These are the ones where all you had to intend was to do the actus reus. Whereas, still under the majority view, voluntary intoxication cannot negate the mens rea of a general intent crime. And the idea is that these general intent crimes don't require much of a state of mind. Just, I mean, if you need to touch somebody, or you need to, how much thoughtfulness does it take to reach out and touch someone or something? So the general intent crimes are crimes that just require the intent to do the act. And so the general policy has been, intoxication, you're not going to get so intoxicated that you cannot even intend to do the act. You may not be able to intend to do the act for some other purpose. You assault with the intent to kill. You took and carried away the property with the intent to steal, and so forth. You may not be able to have that second intent, but people just basically don't get so intoxicated they can't even intend to do the act. And so that's why the general policy has been, and the majority rule still is, that if you're looking at general intent crimes, intoxication just doesn't matter. If you're looking at specific intent crimes, if the person's intoxicated enough, you can negate that specific intent. Now, there are three minority positions. One minority position, the one in Texas, says that voluntary intoxication cannot negate any mens rea, neither the specific nor the general or any other mens rea. That voluntary intoxication doesn't get you anything in Texas. What it really does get, by the way, in Texas is that at sentencing time, the judge can take it into account at that time, but not till then. So one minority position is that voluntary intoxication will not negate any mens rea, neither specific nor general. There's another minority position that says that voluntary intoxication can negate any mens rea, both general and specific. Now, this does not include recklessness or negligence, but except for those, you can negate any other mens rea. California says that voluntary intoxication can negate actual mens rea, but cannot negate the capacity to form the mens rea. Finally, the Model Penal Code. Now, you would apply, if you use the Model Penal Code, you're using that only in those situations where the legislature has passed some fairly new laws, and these new laws use the language of the Model Penal Code. The new laws talk about purposely and knowingly and recklessly and negligently. And so if you have one of these new statutes, rather than the old ones we're talking about, that are in the language of the Model Penal Code, the rule is that that voluntary intoxication can negate purposefully, because that takes some planning. It can negate knowingly, but it cannot negate reckless or negligence. Model Penal Code, voluntary intoxication cannot negate reckless or negligence. I think we mentioned that earlier over here. Let's go back now and pick up on, we said here, if you have a statute written under the Model Penal Code and the statute calls for purposely or knowingly, that you can negate this state of mind by voluntary intoxication. Recklessly and negligently cannot be negated by voluntary intoxication. That really, if you get a problem involving this, what you would want to say to the bar examiners, first, make your distinction between voluntary and involuntary intoxication. Then you'd start with this general rule. You say, as a general rule, voluntary intoxication is not an affirmative defense, but it may be able to negate the mens rea of a crime. That the majority rule is that voluntary intoxication can negate specific intent of a crime, but cannot negate general intent. Here, then you apply Ugat. And you say there are two minority positions. There are three of them. And if you have time, it seems appropriate, you can say a sentence or two about this. And that's how you would answer a question dealing with whether or not intoxication will work as a defense. You should do well if you do this. You'll know more than your counterparts, and you should do well, and I hope you get a question. That's the end of this lecture.